ओके एंडी, ये हटा दे, लेट्स बिगिन। हेलो दोस्तों, लेबर लॉ एडवाइजर चैनल के इस लाइव वेबिनार नंबर 12 में आप सभी का स्वागत है। बहुत दिनों बाद मिल रहे हैं, बट मिलकर अच्छा लग रहा है। और आज एक बहुत ही इंपॉर्टेंट टॉपिक पर अपन डिस्कशन करने वाले हैं, वो है कोड ऑन सोशल सिक्योरिटी, हॉट टॉपिक ऑफ द टाइम। तो अभी आज उस पर अपन डिस्कशन करेंगे एक बेहतरीन स्पीकर के साथ, एक ऑथर के साथ, एक एचआर मैनेजर के साथ और एक पर्सन जो अपने YouTube चैनल के साथ आपके साथ नॉलेज शेयर करते हैं। वो सारी चीजें मैं आपके साथ बताऊंगा, बट इससे पहले कि आप मुझे एक बार कंफर्म करके बता दो कि आपको आवाज प्रॉपर आ रही है कि नहीं। आज वापस मैं आई एम बैक टू माय होम दिवाली के लिए, तो जो रेगुलर सेटअप है वो आज नहीं है, मंदीप भी नहीं है, मैं अकेला ही कर रहा हूँ। तो अगर आवाज वगैरह आपको प्रॉपर आ रही है तो बता दीजिए, एक बार कंफर्म कर दीजिए। कैन यू हियर मी? इफ यू कैन हियर मी, प्लीज एक बार कमेंट में मुझे हाय हेलो लिख के बता दीजिए, या वीडियो को एक बार लाइक कर दीजिए, तो आई विल अंडरस्टैंड कि आप मेरी आवाज सुन पा रहे हैं। चलिए, तो आज के लाइव वेबिनार का अपना जो टॉपिक रहेगा, अनिरुद्ध, आई ऑल्सो रिक्वेस्ट यू टू एक बार लिंक ग्रुप पे शेयर कर दीजिए ताकि बाकी जो मेंबर्स हैं वो देख पाए, एंड एक बार कम्युनिटी टैब पे भी आप शेयर कर दीजिए एक्सक्लूसिव मेंबर्स के लिए। तो आज के वेबिनार में हम लोग डिस्कशन करेंगे कोड ऑन सोशल सिक्योरिटी के बारे में। कोड ऑन सोशल सिक्योरिटी अभी एक रीसेंट हमारा अमेंडमेंट है। रीसेंट अभी ये बिल पास हुआ है और उसके अंदर 9 एग्जिस्टिंग लॉज को, जिसमें मोस्ट इंपॉर्टेंट है ईएसआई और पीएफ, उनको कंबाइन करके एक ओवरऑल कोडिफाई कर दिया गया है, जिसे हम बोलते हैं कोड ऑन सोशल सिक्योरिटी। और कंप्लायंस पर्सपेक्टिव से एज अ एचआर, एज अ कंसल्टेंट, आपके लिए सबसे इंपॉर्टेंट कोड ऑन सोशल सिक्योरिटी ही होने वाला है। तो इस कोड के बारे में आज हम हमारे गेस्ट स्पीकर के साथ बात करेंगे। उनका मैं थोड़ा सा आपको इंट्रोडक्शन दे देता हूं। आज के जो हमारे स्पीकर हैं वो हैं जनरल मैनेजर ह्यूमन रिसोर्स एट कर्न लाइबर्स इंडिया प्राइवेट लिमिटेड। अगर ये मैंने प्रोनाउंसिएशन सही नहीं किया है तो विल आस्क फ्रॉम हिम। बेसिकली दिस इज अ जर्मन एमएनसी कंपनी विद मोर देन 500 एम्प्लॉइज जिनको ये मैनेज करते हैं। he has multiple degrees, बहुत सारी डिग्रीज है। he has done post graduation in human resources, then he has done MBA, and he is also an LLB from Bangalore University. He has over 20 years of experience across the various sectors and working with various different companies, from pharmaceuticals to engineering and beverages, food, etc. So बहुत ही diverse experience है आपके पास। और most importantly, he has written couple of books on labor relation and industrial law as well. His one of the most famous book is Managing Labor Relation, a practical handbook with strategies and technique. So it's a very good book. Another book he has written in Kannada language. So he will be sharing his knowledge with us today, and he has done various programs and various seminars across platform. So I invite our today's speaker, Mr. Govindaraju NS, and he's also running a YouTube channel called 3LR Partner, and very interesting name. It's Labor Law and Labor Relation, 3LR Partners. Is it correct, sir?
Yes, 100%. You're right, Rishabh. Thank you.
Would you like to add something which I have missed?
No, I think you already talked about me, more about whatever I have shared it already. So I think it's more rather than I say something. So we should go ahead with the talk and the presentation, and then to avoid wasting the time.
Before we begin, just a informal question. Like most of our community members are HRs, and they all are complaining that we don't have enough time and there's so much pressure of work and etc. Still, you managed to have written 2 books, and you are running a YouTube channel, and you are studying so much about these codes and laws. How do you manage that?
मैं एक बात बताऊं आपको
जी.
It is actually it's an art. So to tell you that art, people have to give me fees. So
थोड़ा hint दे दीजिए सर, थोड़ा सा.
Basically, you should know, you should have certain tactics to manage your boss and the company. And boss, matlab, you have 2 bosses basically, one in the house and one in the office as well. So if you know how to manage your bosses, then your 50% of the work is done. And other than that, your team, basically how you develop your rapport with your team and also your leadership. And any moment they get any doubt on your capabilities, then you are gone. So you should never give an opportunity to doubt your capabilities, and then they support your initiatives as long as you don't compromise your responsibilities. So far I have been able to manage these dynamics and bosses also, and I've
Hmm.
made a good team with me, so which they take care of all routine jobs. And what I've heard, what I know from the field is people are unable to prioritize their activities and also develop people. If they develop their down the level people, their
Hmm.
responsibility is done. So normally we don't develop, so that's the problem we have. So we have a fear that they will take over our jobs, which I don't have that fear.
परफेक्ट सर. सो दो गुरु मंत्र ले लीजिए अभी तक इसमें. मैनेज हाउ टू मैनेज योर बोथ बॉसेस एट होम एंड इन ऑफिस, एंड हाउ डू यू मैनेज योर basically employees or the person whom you are managing. Basically you need to empower them, give them knowledge, and don't worry about your, like, what if he learns enough and then takes my job or something like that, because that probably never happens.
Exactly. I always say, people always also say that I don't have power in my company, and I am not empowered to do anything. But that's all I say. It's only a reason. So the power, nobody will give you the power. You have to take the power.
Right, sir. So, sir, I am now taking a back seat. You can start
Yeah.
with the presentation. In midway, we will take some questions, and towards the end, we will take some questions, sir. And
Oh,
we
sure.
are sure. Okay, sir.
Thank you, Rishabh, first of all, and also Labor Law Advisor for inviting me today as a speaker. And I am quite honored to know this also and to be a speaker in your Labor Law Advisor, because I also sometimes watch your YouTube. And to also tell you, Rishabh, I am also quite inspired and impressed with your YouTube work. Before I started my channel, I also looked at your how you manage your YouTube channel and also present. And later that I started my a small channel which is around with 60 videos. Of course, if it is of help to professionals, I am very happy. So with this note, I will go to my presentation. Hope my presentation is able to see. Anirudh?
Yes, sir. You can click on hide. You can click on hide. There's a hide on at the bottom. And
Yeah. So
it's working good. It's working good. You can yes. Click on this.
okay, good. So it's okay now.
Perfect, sir. Go ahead.
Good. My brief profile, it's already read out and introduced by Rishabh. I don't want to waste my time. So my channel is 3LR Partner. I also have my own website, which is called www.labor-relation.com. So here I have certain articles and quiz and also a lot about my book. So you can, if you have time, you can visit this and also get to know more about it. And my channel you already know. I'm not going to talk more about it. There are many videos on different topics. Of course, they are quite informative and lengthy, because any information which is given off, then it is not an information. Therefore I try to cover up those information and give as maximum as possible. That's why there sometimes you may feel that's quite lengthy, but I feel they are informative and useful for all of you. And of course you get many more videos there. If you are interested, you can visit and also subscribe to the channel for more updates. Now let me tell you what I will cover in this webinar. Of course, I and Rishabh agreed that after 30 minutes there will be a break for question and answer if there are any questions to from the viewers. After that we will still continue, and at the end we may still have certain questions. So in this webinar I will cover comparative analysis of application of the code, because this code has got 9 legislations amalgamated. So therefore there is a deep look is required an analysis of the application of the code. And we will also talk certain key definitions, because If we don't know these definitions, then application becomes very difficult. Therefore, we will also look into certain very key definitions very briefly for our understanding, and also to have the right perspective on that. And as LLA said, we will look into key changes which benefit employees as well as benefit employers also. And we will also look into certain other key changes. And at the end, of course, as usual, we make certain conclusions, and we will open for question and answer. With this, let me begin. And also, LLA said how it will impact the compliances. Of course, compliance is also very important because of the changes which have happened. You will also get to know how it will impact your compliance part of it during the course of this webinar. And now, as you know, already this Social Security Code, or Code on Social Security 2020, has amalgamated 9 legislations which are basically related to Social Security, which are namely, employees compensation, employees state insurance, employees provident fund, which are basically provident fund, employees pension scheme, and also the insurance, which is employees deposit linked insurance, and Employment Exchanges Act, which is we famously called as CNV, or Compulsory Notification of Vacancies, and the Maternity Benefit Act, Payment of Gratuity Act, and Cine Workers Welfare Fund Act, and BOCW Welfare Cess Act, and of course finally the Unorganized Workers Social Security Act 2008. These are the 9 legislations which are amalgamated. And if you look at these all 9 legislations, there were 256 sections and 12 schedules, and all these provisions and schedules are now amalgamated into 164 sections and with 7 schedules. And to compare with 2019 bill and 2020 bill, 2019 bill had 163 sections and 6 schedules, whereas now there is an addition of 1 section and 1 schedule. So we will proceed with this, and let me give you a comparative analysis of application of the code, because we have to understand importantly how the application of the code is taking place. Let's compare the 9 legislations which are very important for us, and also what is the code is talking about. Now I am telling you about the coverage. So if you look at the coverage of the code intends to extend Social Security for all employees and workers, either in the organized or unorganized. And there is another word is also written, that any other sector. Even the law is not, law is unsure also about it, because the changing dynamics are telling us to think more about these sectors. That is why the code also says any other sector, whether it is organized or unorganized, or tomorrow we may call different names. That is why it is talking any other sector also. And specific application of the chapters are provided in the first schedule. So there is a first schedule to the code, and all application related to various benefits are now summarized in first schedule. And however, this first schedule does not bar the application of other provisions of the code. So with this, we will get into certain application classes. So let me give you a brief about Provident Fund, how it was in EPF and Miscellaneous Provisions Act 1952, and also how it was in how it is in Social Security Code. So if you look at EPF and Miscellaneous Provisions Act 1952, the application is factory having 20 or more persons and engaged in industry specified in Schedule 1. So two things were important: factory having 20 or more persons and engaged in industry specified in Schedule 1. So both are important for application of this act. And there was a possibility for the central government to notify other establishments having 20 or more persons. And there was also another possibility for the central government to notify other establishments having less than 20 persons. And there was also voluntary application if the employer and employees agree to apply the provisions and makes an application to the Central Provident Fund Commissioner. And this coverage will continue even if the number of persons reduced to less than 20 at any time after the coverage. And this was the situation where with the 1952 Act. Now let's look into what is Code on Social Security 2020 is talking about application of Provident Fund. So if I look at the code, every establishment in which 20 or more employees are employed. So there is no question of Schedule 1 which is talking about engaged in industry specified in Schedule 1. So there is no Schedule 1. And possibility for the central government to notify other establishments having not less than such number as specified in the notification. So note this difference. Earlier there was talking about 20 employees, and now so any number the central government can notify the applicability of Provident Fund chapter. And there is also a voluntary application if the employer and the employees agree to apply the provisions and makes an application to Central Provident Fund Commissioner. And there is also possibility for the establishment who have covered voluntarily to come out of the coverage. See, earlier this provision was not there. Now there is a exit route is also available for those companies who are voluntarily covered if the employer and employees agree by way of agreement and makes an application to CPFC. So this exit route was not existing in the current law. So now the existing route is given only for the companies or the establishments who have covered voluntarily. And as I said, Schedule 1 of the Employees Provident Fund and Miscellaneous Provisions Act 1950 is dropped because now it has got it has no relevance. And coming back to so the establishment once covered at the first instance as per the first schedule, and this will continue to cover even if the number of employees gets reduced to less than the threshold. And this is only applicable in case of regular coverage and not voluntary coverage. If some companies have covered voluntarily, they always have the exit route if both employer and employees agree to make it inapplicable. So then the CPFC or whoever is the officer is bound to make it inapplicable. So that exit route is provided in the code. Now let me come to Employee State Insurance Act 1948. If I look at this act applies to all factories except seasonal factories, and it does not apply to government factories if the employees are in receipt of similar or superior benefits. And there was a possibility for the appropriate government to extend the act to any other establishment in consultation with the corporation and central government. And of course,
I have a small request. If possible, yes, with you, can you speak little bit in Hindi in between, if possible? Because our audience are not at all comfortable with English.
Yeah, मेरा हिंदी तो उतना अच्छा नहीं है, but
a little bit somewhere here and there. So
हाँ ठीक है, ये मैं कर सकता हूँ.
Okay, ये
yeah, okay. ये coverage जो था, suppose if any company has got any in the future date, if if the manpower is reduced, that coverage is also continued without any stop. So this was the ESI Act. Now ये जो ESI Act है, this extension is also based on the coverage of the area, and before this coverage of extension of benefit is necessary. But however, this condition, whether it is there in the code or not, we will see it. Now we will look into code on social security, how this coverage is taking place. And if at all, if you see this code now, every establishment, जो establishment होता है, उसमें 10 आदमी or more employees, if they are employed, then a code cover होता है, except seasonal factory. So that is the except seasonal factories is continued. And this prescribed manpower criteria is not applicable to establishment carrying hazardous or life-threatening occupation. Even a single employee is also sufficient. So, जो मैं बता रहा हूँ आपको, suppose आपका industry hazardous nature और life-threatening occupation में है, so उसके लिए ये manpower 10 आदमी या 10 or more, so उसका criteria नहीं होता है. So even ये single आदमी या single employee रहता है, उसको भी code on social security cover हो जाता है. So that is the meaning, coverage of social security code in case of ESI Act. And employer of plantation can get it covered voluntarily by giving willingness to the corporation. See what happens in plantation, because a plantation में अपना hospital और अपना facilities होता है. So now the code has brought that even the plantation can get it covered voluntarily by giving willingness to the corporation. So वो possibility अभी code में लाया गया है. Now payment of contribution is applicable only from the date of extension of benefits from the corporation and such date to be notified by the central government. जो अभी है, suppose if एक एरिया में ESI ESI benefits extension नहीं हुआ है, उसमें contribution नहीं मांग सकता है. वो जो था प्रोविजन, वो प्रोविजन अभी भी कोड ऑन सोशल सिक्योरिटी में है. और मैं आपको बताया पीएफ में ये वॉलेंट्री एप्लीकेशन जो होता है, सपोज आपका कंपनी में 10 आदमी के नीचे है एम्प्लॉइज, सो उस वक्त आप फिर भी वॉलेंट्री बेसिस में कवर कर सकता है. सो कवर करने के बाद आपका एग्जिट रूट भी इसमें है. पॉसिबिलिटी फॉर द एस्टैब्लिशमेंट्स हु हैव कवर्ड वॉलेंटरली to come out of the coverage if the employer and employees agree by way of agreement and makes an application to डायरेक्टर जनरल ऑफ द कॉर्पोरेशन. सो मैं क्या बोल रहा हूँ, सपोज आपका कंपनी में 10 के नीचे है और यू वांट टू गेट इट कवर्ड and you can get it covered if both your employees and employer agree and makes an application to director general. So आपका after some time you don't want to continue the cover. Now आपके पास वो exit route भी है, so you can utilize that both opportunities in वो provident fund और ESI में ये opportunity आप use कर सकता है. Now so मैं बोला suppose आपका regular coverage में 10 आदमी के नीचे आ जाता है फ्यूचर में, so then you cannot say now the code does not cover. The code will continue to cover because this provision was there earlier and this provision is there, continue to be there in the code as well. Now let me tell you about gratuity. See, the gratuity is dealt by Payment of Gratuity Act 1972 and आप इसमें coverage देखा तो ये ऑल फैक्ट्रीज, माइन, ऑयल फील्ड, प्लांटेशन, पोर्ट एंड रेलवे कंपनी को कवर हो जाता है. और ये शॉप्स और एस्टैब्लिशमेंट होता है ना, वो इट आल्सो अप्लाइज टू दिस काइंड ऑफ शॉप्स और एस्टैब्लिशमेंट covered under the state shops and establishment acts. उसमें 10 or more persons employed or were employed on any day of the preceding 12 months. So ये 12 months के अंदर आपके शॉप और एस्टेब्लिशमेंट में 10 आदमी है तो 10 और मोर आदमी है तो पेमेंट ऑफ ग्रेजुएटी एक्ट 1972 कवर हो जाता है. और इसमें जो था सेंट्रल गवर्नमेंट के पास एक पावर था. The power is central government can also notify other establishment employed 10 or more employees or were employed on any day of the preceding 12 months. वो सेंट्रल गवर्नमेंट के पास ये पावर भी था. और वो as usual coverage to continue even if the number of employees falls below 10 at any time after the coverage. So अभी कवर हो गया, रेगुलर कवरेज हो गया. आपका फ्यूचर डेट में 10 आदमी के नीचे आ गया आपका मैन पावर, देन उस वक्त वो कवरेज कंटिन्यू हो जाता है, स्टॉप नहीं हो जाता है. सो ऐसा पेमेंट ग्रेजुएटी एक्ट 1972 प्रोविजन, उसमें प्रोविजन है. Now अभी हम कोड ऑन सोशल सिक्योरिटी में क्या बदलाव हुआ है वो देखेंगे. So suppose if you see now at the first instance applies to all factories, mine, oil field, plantation, port and railway company. So as usual वो फर्स्ट क्राइटेरिया था ना, so वो फर्स्ट क्राइटेरिया अप्लीकेबल हो जाता है. एंड द सेकंड क्राइटेरिया इज आल्सो सेम. ये आपका शॉप हो, एस्टैब्लिशमेंट हो, उसमें 10 और मोर एम्प्लॉइज है तो लास्ट 12 मंथ्स में 10 और मोर एम्प्लॉइज है तो कोड ऑन सोशल सिक्योरिटी भी बोलता है ग्रेजुएटी प्रोविजंस कवर हो जाता है. और एक बदलाव हुआ है, पॉसिबिलिटी फॉर द अप्रोप्रिएट गवर्नमेंट टू नोटिफाई अदर शॉप्स और एस्टैब्लिशमेंट फ्रॉम टाइम टू टाइम फॉर कवरेज. सो आप ग्रेजुएटी एक्ट देखा तो उधर सेंट्रल गवर्नमेंट को पावर था टू कवर अदर एस्टैब्लिशमेंट, शॉप्स और एस्टैब्लिशमेंट. अभी क्या हुआ है, अप्रोप्रिएट गवर्नमेंट को ये पावर दिया है. अप्रोप्रिएट गवर्नमेंट इन द सेंस इट कैन बी आपका स्टेट गवर्नमेंट भी हो सकता है, सेंट्रल गवर्नमेंट भी हो सकता है. नाउ स्टेट गवर्नमेंट can also make it applicable for any other shops or establishment. So now this provision has been brought and as usual the जो आपका establishment cover हो गया, future में आपका मैन पावर reduce हो गया, reduce to less than, so then आपका coverage continue हो जाता है, it doesn't stop. So that is the code on social security with reference to gratuity. And as usual इधर क्या होता है, आपका सेंट्रल गवर्नमेंट जो है उसको दो स्टेटस है. वन इज एज एन अप्रोप्रिएट गवर्नमेंट एंड एज एन इंडिपेंडेंट पावर. सो उसको दो पावर है. एज एन इंडिपेंडेंट पावर इट कैन मेक दिस प्रोविजंस एप्लीकेबल टू एनी अदर एस्टैब्लिशमेंट हैविंग एम्प्लॉइज लेस देन द थ्रेशोल्ड. वो जो थ्रेशोल्ड है 10 or more employees, even if suppose any company or establishment does not have, so the central government can independently make it for applicable to entire country. So that power central government also has got, in addition to as an appropriate government. So वो central government के पास दो power है, as an appropriate government, as a central government. Now we will get into maternity benefit. So ये maternity benefit act 1961 के मुताबिक, see this act applies to all factories, mine or plantation, including establishments belonging to government, and where persons are employed for exhibition of equestrian or acrobatic and other performances. These acrobatic or something like this is your circus, gymnastic, all those things ऐसा आ जाता है. So at the first instance ये फैक्ट्री, माइन, प्लांटेशन, तो उसको अप्लीकेशन हो जाता है. एंड वो एज यूजुअल ये आपका एस्टेब्लिशमेंट शॉप और एस्टेब्लिशमेंट हो स्टेट एक्ट में कवर हो, उसमें 10 और मोर पर्सन्स एम्प्लॉय हुआ तो मैटरनिटी बेनिफिट एक्ट 1961 आल्सो गेट्स कवर्ड अंडर फॉर द प्रोविजंस. सो इसमें क्या था, टू कवर any other establishment, either state government with the approval of the central government has the possibility. So your state government would have could have used that power, even if at all if it wants to use that power, usko central government ka approval chahiye tha. So to make it applicable for any other establishments. So now what happened in the code, we will also see that. And the provisions are not applicable to employees who are covered under ESI Act and qualified to avail maternity benefit. So this आपको पता है, ESI Act also gives maternity benefit, and maternity benefit act also has got some coverage. Suppose आपका कंपनी में किसी एम्प्लॉय को एम्प्लॉय स्टेट इंश्योरेंस एक्ट कवर हुआ है एंड उसको मैटरनिटी बेनिफिट उसका एक्ट अंदर से मिल रहा है, देन ये मैटरनिटी बेनिफिट एक्ट का प्रोविजंस उसको अप्लीकेबल नहीं होता है. सो ऐसा प्रोविजन उसका अंदर था. नाउ अभी देखेंगे कोड ऑन सोशल सिक्योरिटी में क्या प्रोविजन लाया गया है. सो फर्स्ट क्राइटेरिया, ये सब फैक्ट्रीज को, माइन और प्लांटेशन इंक्लूडिंग गवर्नमेंट एस्टेब्लिशमेंट्स को अप्लीकेबिलिटी है. और एंड सेकेंड क्राइटेरिया इज ऑल्सो सेम, आपका कंपनी शॉप और एस्टेब्लिशमेंट है तो 10 आदमी और मोर एम्प्लॉइज है तो पिछले 12 महीने में आपके पास 10 और मोर आदमी है तो देन प्रोविजंस ऑफ दिस चैप्टर बेसिकली मैटरनिटी बेनिफिट एक्ट अप्लाई हो जाता है. एंड नो मैं बोला आपको मैटरनिटी बेनिफिट एक्ट में स्टेट गवर्नमेंट के पास पावर था टू मेक इट अप्लीकेबल टू अदर एस्टेब्लिशमेंट. ऑफ कोर्स उसके लिए सेंट्रल गवर्नमेंट का अप्रूवल चाहिए था. अभी क्या हुआ है, possibility for the appropriate government to apply the provisions to any other shops or establishment. Now it is only rests with appropriate governments. See this appropriate government definition हम देखेंगे थोड़ा डिटेल से, आपको पता चल जाएगा if you don't know. So appropriate government can be state government as well as central government. So उसके बारे में हम बताएंगे. और एक power है, central government holds the power as appropriate government and also has independent power to make the provisions of the code applicable to any establishment having employees less than the threshold. So मैं बोला आपको gratuity provision में central government को दो kind का power हो जाता है. One as a independent power to make the provisions applicable to entire country, another one as an appropriate government only limited to where certain kind of establishments are coming under the central government purview. So दो power उसको central government को अभी कोड में लाया गया है. और the establishment once covered at the first instance as per the first schedule will continue to cover even if the number of employees get reduced to less than the threshold. So this is very common to all other chapters. आपका एस्टेब्लिशमेंट अभी कवर हो गया और बाद में मैन पावर रिड्यूस हो गया, so then you can't say that gratuity or maternity benefit act provisions मेरे को अप्लाई नहीं होता है, ऐसा नहीं बोल सकता है. So that provision has been clearly brought in the code as well. Now I'm coming back to Employees Compensation Act 1923, which is also amalgamated. उसका क्या था, at the first instance it applies to a railway servant, a master, a seaman or other member of the crew of a ship, a captain or other member of the crew of an aircraft. So आप ये एक्ट देखा तो इसमें लिखा हुआ है क्या क्या एप्लीकेशन है, किस किस को एप्लीकेशन है, बिकॉज दिस इज आल्सो समथिंग सिमिलर टू sorry, this is also something similar to, 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 this is also someth दिस इज ऑल्सो सिमिलर टू ESI. सपोज आपका कंपनी को ESI अप्लीकेबल होता है और वो एम्प्लॉय ESI में अंदर है, सो देन एम्प्लॉयज कंपनसेशन एक्ट नहीं अप्लाई नहीं होता है. सो एम्प्लॉयज कंपनसेशन एक्ट में लिखा है क्या क्या किस किस का एम्प्लॉय को ये एप्लीकेशन होता है. सो सेकंड इंस्टेंस में applies to a person employed as a driver, helper, mechanic, cleaner or any other capacity with a motor vehicle. And this also applies to a person recruited for work abroad in a company, and this applies to a person employed outside India any capacity specified in schedules 2, and also the ship, aircraft or motor vehicle or company registered in India. So ये compensation act application होने के लिए एक schedule is important है, schedule 2. So ये schedule 2 में क्या होता है, उसमें लिखा हुआ है क्या क्या काम करने वालों उसको कंपनसेशन एक्ट अप्लीकेबल होता है. सपोज इफ देयर इज नथिंग इन द शेड्यूल 2 एंड दैट एम्प्लॉय इज नॉट कवर्ड अंडर शेड्यूल 2, देन ये कंपनसेशन एक्ट अप्लीकेबल नहीं होता है. नाउ ये शेड्यूल 2 में बहुत सारे काम लिखा हुआ है. This is basically nature of tasks, railway operation, maintenance, employed in the premises where manufacturing process is carried out. तो ये क्या होता है ना, आपका फैक्ट्री है, फैक्ट्री के अंदर जो भी काम करता है उसको एम्प्लॉइज कंपनसेशन एक्ट अप्लीकेबल होता है. और सपोज वो किसी ने ESI में नहीं है, देन वेदर आपका मैनेजर हो, क्लर्क हो या ऑपरेटर हो, जो भी है वो मैन्युफैक्चरिंग प्रोसेस किधर भी कैरी होता है ना, उसका प्रीमिसेस में काम करते हुआ तो देन द एम्प्लॉइज कंपनसेशन एक्ट अप्लीकेबल होता है. सो हैंडलिंग ऑफ एक्सप्लोजिव्स, ऐसा बहुत सारे ऑपरेशंस और टास्क उसमें लिखा हुआ है. नाउ मैं आपको बोला बाय वर्च्यू ऑफ सेक्शन 53 ऑफ ESI एक्ट 1948, एम्प्लॉइज कवर्ड अंडर ESI आर नॉट एंटाइटल्ड टू एनी बेनिफिट्स अंडर दिस एक्ट. सो आपका किसी एम्प्लॉय को ESI एक्ट अप्लीकेबल हुआ तो एम्प्लॉइज कंपनसेशन एक्ट 1923 इज अप्लीकेबल नहीं है. और अभी हम देखेंगे कोड ऑन सोशल सिक्योरिटी में क्या बदलाव लेके आया है. सो फर्स्ट इंस्टेंस में दिस provision of employee compensation applies to the employees and employees to whom chapter 4 does not apply. See, this chapter 4 does not apply in the sense chapter 4 is nothing but ESI. Suppose ESI chapter आपका एम्प्लॉय को अप्लीकेबल होता है, your employee is covered under ESI chapter, then this code on social security and this who is the employee is also important. किस किस को कवरेज होता है? Employees are only those persons specified in schedule 2 of the code. See, आप थर्ड प्रोविजो ऑफ सेक्शन 226 आप देखा तो उसमें लिखा हुआ है किस किस को ये कवरेज होता है. एम्प्लॉय कंपनसेशन एक्ट प्रोविजन चैप्टर के व्हाट टाइप ऑफ एम्प्लॉइज आर कवर्ड उसमें लिखा हुआ है. सो शेड्यूल 2 में हम जाके देखेंगे वेदर ये एम्प्लॉई कवर हुआ है या नहीं कवर हुआ है. सो विथ सब्जेक्ट टू दैट कंडीशन द कंपनसेशन चैप्टर अंडर द कोड ऑन सोशल सिक्योरिटी इज एप्लीकेबल. नाउ both central and state government can amend the schedule. So दोनों गवर्नमेंट, सेंट्रल एंड स्टेट गवर्नमेंट इसमें अमेंड कर सकता है. ये शेड्यूल 2 है उसमें अमेंड कर सकता है. And the schedule 2 of the Employees Compensation Act 1923 is exactly reproduced as it is. वो जो था एम्प्लॉय कंपनसेशन एक्ट 1923 में ये शेड्यूल 2 जो था उसको ऐसा ही लेके आया है. और ये उसमें वन एडिशन 2 एडिशंस दिया है और 1 डिलीशन राइट करके ऐसा ही लेके आया है. और नाउ हम BOCW which is बिल्डिंग वर्कर्स वेलफेयर सेस एक्ट, सो 1996 के बारे में थोड़ा बताएंगे. उसमें क्या था, अप्लाइज टू एवरी एस्टैब्लिशमेंट्स इन्वॉल्व्ड इन बिल्डिंग एंड अदर कंस्ट्रक्शन वर्क्स. इसमें क्या है, सिमिलर टू इट, ये अप्लाइज टू एवरी एस्टैब्लिशमेंट व्हिच फॉल्स अंडर द बिल्डिंग एंड अदर कंस्ट्रक्शन वर्क. सो इसमें ज्यादा डिफरेंस नहीं है. BOCW वेलफेयर सेस एक्ट और कोड ऑन सोशल सिक्योरिटी एक्ट जो बिल्डिंग सेस के बारे में बताता है उसमें ज्यादा डिफरेंस नहीं है. हम अभी अनऑर्गेनाइज्ड वर्कर सोशल सिक्योरिटी एक्ट 2008 का कवरेज और कोड ऑन सोशल सिक्योरिटी का कवरेज थोड़ा बताते हैं. इसमें क्या होता है, ये UWSS एक्ट 2000 जो था ये अप्लाई होता है होम बेस्ड वर्कर, सेल्फ एम्प्लॉयड वर्कर और वेज वर्कर इन द अनऑर्गेनाइज्ड सेक्टर and includes a worker in the organized sector who is not covered by any of the acts mentioned in Schedule 2 to this act. So उसमें एक Schedule 2 है, उसमें लिखा हुआ है, certain acts दिया है. Suppose any employee उसमें कवर हो जाता है वो एक्ट में, then इस एक्ट के अंदर वो नहीं आता है. So इस ऐसा प्रोविजन दिया है. एंड उसके अनऑर्गेनाइज सेक्टर का डेफिनेशन भी दिया है. से अनऑर्गेनाइज का सेक्टर का डेफिनेशन है, इट मींस an enterprise owned by individuals or self-employed workers and engaged in the production or sale of goods or providing service of any kind of whatsoever, and where the enterprise employs workers, the number of such workers is less than 10. So suppose any self-employment करता है, उसमें सेल्फ इंडस्ट्री है, उसमें 10 आदमी के नीचे है तो वो अनऑर्गेनाइज सेक्टर में आ जाता है ना. वो शेड्यूल 2 में मैं बताया ना, उसके वो 6 एक्ट लिखा हुआ है, वर्कमैन कंपनसेशन एक्ट, इंडस्ट्रियल डिस्प्यूट एक्ट, एम्प्लॉय स्टेट इंश्योरेंस एक्ट, एम्प्लॉय प्रोविडेंट फंड एक्ट, मैटरनिटी बेनिफिट एक्ट, पेमेंट ऑफ ग्रेजुएटी एक्ट. सो एनी कंपनी इज कवर्ड अंडर दीस एक्ट्स, देन यूडब्ल्यूएसएसए एक्ट एप्लीकेबल नहीं हो जाता है. सो ऐसा ही प्रोविजन कोड ऑन सोशल सिक्योरिटी में लेके आया है. अभी देखेंगे क्या चेंजेस है उसमें. अप्लाइज टू अनऑर्गेनाइज्ड सेक्टर, अनऑर्गेनाइज्ड वर्कर्स एंड गिग वर्कर्स एंड प्लेटफॉर्म वर्कर्स. सी एप्लीकेबिलिटी ऐसा ही है, लेकिन दो तरह का एम्प्लॉइज को ऐड किया है. वन इज गिग वर्कर्स एंड प्लेटफॉर्म वर्कर्स. उसके बारे में थोड़ा हम बताएंगे बाद में. मैं भूल गया तो मेरे को बात कर सकता है. सो आई कैन आल्सो टॉक अबाउट हु आर दिस गिग वर्कर्स एंड प्लेटफॉर्म वर्कर्स. एंड अनऑर्गेनाइज्ड सेक्टर डेफिनेशन इज रिटेन्ड एज इट इज. वो जो मैं बताया वो क्या अनऑर्गेनाइज्ड सेक्टर है, सो वो सेम डेफिनेशन इधर रिटेन किया है. नाउ अनऑर्गेनाइज्ड सेक्टर वर्कर्स एक्सक्लूड्स वर्कर्स कवर्ड अंडर आईडी एक्ट. मैं बताया ना शेड्यूल 2 में जो लिखा हुआ है, इधर वो चैप्टर नेम लिखा हुआ है. So if any employee is covered under PF, PSA, gratuity, maternity benefit and employee compensation, वो ये चैप्टर के अंदर वो एम्प्लॉय नहीं आता है. Now ये gig and platform workers, वो even though these unorganized workers social security schemes बताया गया है, but gig and platform workers are not classified as unorganized workers, and separate schemes get notified by the central government for gig and platform workers. So ये gig and platform workers को अनऑर्गेनाइज्ड क्लासिफिकेशन नहीं दिया है. उसके लिए सेंट्रल गवर्नमेंट या स्टेट गवर्नमेंट सेपरेट स्कीम्स को लेने के लिए वो प्रोविजन लेके आया है. एंड वो उसमें 2 शेड्यूल था, यूडब्ल्यूएसएस एक्ट में 2 शेड्यूल था, शेड्यूल 1 एंड 2. सो नाउ वो उसको ड्रॉप किया है बिकॉज उसका अभी रिलेवेंस नहीं है उसके लिए. So these schedules have been dropped in the Social Security Code. So now तो हम थोड़ा एम्प्लॉयमेंट एक्सचेंज और सीएनवी एक्ट में थोड़ा बोलेंगे. उसका कवरेज है प्राइवेट एस्टैब्लिशमेंट्स हैविंग लेस देन.
Can you like take couple of minutes of break and take 1 or 2 questions till
Yeah, मैं just give me 1 minute, I will complete the coverage and then we can start it.
Yeah, sure.
So yeah, private establishments having less than 25 are not required to notify the vacancies to employment exchange. So उसमें क्या था, suppose आपका कंपनी में less than 25 है employees, then you are not required to inform any of the vacancies to employment exchange. अभी क्या हुआ है, so that threshold को 20 किया है. और so उसमें वो एम्प्लॉयमेंट एक्सचेंज जो था उसको रीनेम किया है जैसा कैरियर सेंटर्स. ऐसा this has been renamed as career centers. So now Rishabh, I have completed the coverage and I'll get into key definitions. So now we can take certain break, and if there are any questions, I can answer it.
Right, sir. So one question is coming from CA Akhilesh. So he is asking, earlier ESI was not applicable in various areas. According to this code, will it still apply, or now it will be applicable across India?
No, it is still applicable because the provisions are very clear. The provisions clearly बताया गया है. If suppose if there is no application to the area, then the employers cannot be mandated to pay contributions. ऐसा provision है.
Right, sir. There are a couple of questions related to contribution rates. So earlier EDLI was at 0.5%. Is it in this code? It will be increased to 1%. 1% हो जाएगा, ऐसा है?
नहीं, 1% लिखा है, 1% लिखा है कोड में, बट उसमें वो प्रोविजंस में भी लिखा है सेंट्रल गवर्नमेंट कैन वेरी इट. सो अल्टीमेटली क्या होता है, when the government implements this code and brings all the rules and regulations, it may retain as it is, but code में 1% लिखा है अभी, 1% of the wages लिखा है, और 1/4 of the charges of the EDLI contribution, administrative charges जैसा भी लिखा है. But अंत में जो होता है, when implementation gets done, it is up to the central government whether it wants to keep the same rate or if it wants to keep it as at the code, or retain as it is. So that power,
Right.
central government always has it.
It seems that they have copy pasted from the older PF code.
100%. May I'll also tell you certain things where they have also copied and pasted. Lot of provisions are copied.
Right, and even copy pasted from a older I guess act.
Yes, older version.
So even copy में भी थोड़ा दिमाग लगता है.
Yeah. But at least the 2020 bill is much better than the 2019 bill.
Right, sir. So one question is, in this code, there is some flexibility related to contribution of PF rates. So now say code says that government is flexible, they can contribute even at 10%, or what do you see? Will this be applicable soon, or this is just something?
ऐसा नहीं है. Even in the Provident Fund Act, this 10% and 12% story wala, it was there, because at the first instance the law is only talking about 10%. बाद में जो होता है, central government can make this applicable as 12%. So the same situation happened in the Employees Provident Fund and Miscellaneous Provisions Act 1952 also. The law says 10%, but the central government can make it 12% by way of notification, and the same provisions have been brought.
Right. Okay. Mr. Jignesh is asking, for in ESIC covered organization, will applicable for whose salary is more than 21,000. Now, will it be applicable for more than 21,000?
See, what code is saying, this wage ceiling will be notified and prescribed by the central government. Whether they will make it 21,000 or 25,000, we will have to wait for it, because आपको media देख रहा है, अभी वो बोलता है 21,000, they will raise it to 25,000. वो PF के बारे में अभी yesterday I read about it that now from 15,000 to 25,000 they want to increase it. But जो कोड में लिखा हुआ है, सेंट्रल गवर्नमेंट विल प्रिस्क्राइब इट. द कोड में ऐसा वेज सीलिंग लिखा नहीं है.
Okay, last couple of questions I'll ask. Mr. Rajendra Sahu is asking, what about, so what is the limit of coverage, like employee limit for coverage for canteen, software offices, restrooms, all these kind of businesses?
Canteen and all वो shops and establishment में आ जाता है. Now PF में there is a uniform coverage 20 or more employees, and ESI maybe there is now a uniform coverage 10 or more employees. No, earlier it was talking about factories, mines and all. No, now schedule 2 में जो है, so now it is a uniform coverage for everyone. No.
Right, sir. Last question I'm asking, it is related to registers. So now, can we maintain registers in electronic format? Does this code say something about it?
100%. So they have to still wait for my presentation to over, and if everybody listens very peacefully, then I will also talk about little bit about it. And the electronic maintenance of registers and returns have been clearly brought down.
Thank you, sir. So let's continue with the presentation. I'll take a back seat. Thank you.
Yeah, so I will be quite faster because it is already 5:44. So
don't worry, sir. If it's 15-minute extended, also that's fine.
Yeah, because you know me already, because I will get into little deeper, and then we start talking. Then so there is no अंत नहीं होता है उसमें.
No problem, sir.
Okay, good. So I will get into certain key definitions and implications also. So this appropriate government is important for us to understand. जो सेंट्रल गवर्नमेंट का अंदर काम करता है और अंडर द अथॉरिटी में एस्टैब्लिश हो गया है, so उसको हम central government will have the power to control such industries. अभी क्या हुआ है, metro railways have also been brought under central government, because ये railway क्या होता है ना, now earlier it was purely under the government, now it is getting privatized. So that why this provision has been brought. And also ये contractor establishment, suppose if anybody is providing a service to contract, to public sector undertaking, उसके लिए appropriate government is the central government. Earlier ये clarity नहीं था, so ये clarity अभी लेके आया है. And I can say it is an hybrid version of appropriate government definition of all the 9 legislation. So वो क्या किया है, they have looked into all 9 legislations, took all 9 definitions of appropriate government, जो भी एक definition में नहीं था, so इसमें लेके आके एक हाइब्रिड डेफिनेशन बना के इतना सारा बड़ा बना के रखा है. तो नाउ ये कॉन्ट्रैक्ट लेबर डेफिनेशन भी लेके आया है. सो सम एक्ट्स वर नॉट हैविंग दिस कॉन्ट्रैक्ट लेबर डेफिनेशन. नाउ इसमें क्या हुआ है, this contract labor definition also includes interstate migrant workers, but does not include an employee other than part-time employee who is regularly employed by the contractor for any activity of his establishment. For example, you are a contractor, and to manage your business, your office, suppose you have certain employees, then he is not called as contract employees. You provide जो आप दूसरे के लिए प्रोवाइड करता है, सो वो कॉन्ट्रैक्ट लेबर बताया जाता है. सपोज यू कीप योर एम्प्लॉइज फॉर योर वर्क, देन दे आर नॉट कॉल्ड एज contract labor. See, this is very important definition also for coverage of the contract labor. And now contractor definition is also important. See, suppose somebody is producing undertakes to produce a given result, or he supplies contract labor. दोनों both the people are called as contractor. So earlier क्या हुआ था, ये इसमें थोड़ा लीगल डिफिकल्टीज था. इफ योर कॉन्ट्रैक्ट मींस होलसम कॉन्ट्रैक्ट चाहिए. सी इफ यू आर ओनली एम्प्लॉइंग ए कॉन्ट्रैक्ट लेबर, देयर वर लिटिल बिट डिफिकल्टीज by virtue of judgments and judicial pronouncement. Now even if you are supplying mere human resource, like like labors you are supplying, then they are also contractor. Now this employee definition is very important, so I will tell you very briefly. Everybody is covered, whether आप डायरेक्टली उसको अपॉइंट किया है या थ्रू कॉन्ट्रैक्टर और एनी एजेंसी, सो इट डजंट मेक एनी डिफरेंस. एंड आप वो सुपरवाइजर है, मैनेजर है, एडमिनिस्ट्रेटिव कैटेगरी है, that is also not a criteria, so he is also covered under that. Even if you are managing director, he is a working managing director, he is also an employee as per the code. So he should not be a owner, so that is only the criteria. If he is a working managing director, he is also an employee under the code. So ऐसा definition है. And इसमें जो है, मैं अब एक क्वेश्चन आया, suppose if those wage ceilings will be there for application of provident fund and ESI, so that wage ceiling are going to be there, because this proviso 1 and proviso 2 are very clear. So employee shall mean such employee drawing wages less than or equal to the wage ceiling notified by the central government. So in the case of provident fund, now it is 15,000 and below. In the case of ESI, it is 21,000 and below. So this 21,000 and 15,000 ceiling are going to be there. Whether it is 21,000 or 15,000, that is the central government which will decide. And so they are required to notify once the code gets implemented. And of course for employee compensation also, मैं आपको बताया शेड्यूल 1 में जो सेकंड शेड्यूल में जो लिखा हुआ है, so only those categories of employees are covered for employee compensation. Now employer, so उसमें मैं this employer definition very briefly I'll tell you. Employer means any person, whether directly or through any person, employs any kind of employees. So then even if you employ people through from any agency, so then he is also called as an employee. But one good thing is now the contractor is included as employer. So contractor जो था earlier उसका बारे में थोड़ा clarity नहीं था, who is responsible, अभी उसको employer बनाया गया. So the employer definition includes contractor also. And in case of the factory, if somebody is notified as an occupier, he will also be included as employer. So then this fixed term employment के बारे में आपके बताए. So these provision have been brought explicitly. And however, if you employ anybody for on fixed term, he should be given with all statutory benefits and proportionately, even if the if the qualification criteria meets or not, that's not important. If you have employed him as fixed term, then proportionate basis में उसको जो भी statutory benefits including gratuity आना चाहिए उसको देना चाहिए as per the provisions of the code. Now this wage definition is very important. I also try to see certain videos of Rishabh in his channel about the wage code. Wage code में जो wage definition था section 2Y में, the same wage definition pin to pin copy करके उसमें लेके आया है. इसमें दो पार्ट है. क्या वेज, व्हाट इज द वेज मीनिंग, एक इंक्लूजन पार्ट है, एक एक्सक्लूजन पार्ट में. जो वेज इंक्लूजन पार्ट में हम बताएंगे, इस see at the first instance it is called as all allowances or otherwise expressed in terms of money जो भी आप पे करते हैं, then it is called as remuneration or wages. and उसमें इंक्लूजन पार्ट में क्या है, बेसिक वेजेस, डियरनेस अलाउंस एंड रिटेनिंग अलाउंस, ये तीनों इंक्लूजन क्लास में है. और इसके अलावा then they have brought exclusions also. There are 11 exclusions. See, suppose if you pay any bonus, any benefits value, even your provident fund contribution, pension fund contribution, आपका salary structure में conveyance allowance होता है. और if you pay any special expenses, even the house rent allowance is also excluded component. And remuneration payable under any award or settlement, overtime allowance, any commission, any gratuity payable, retrenchment compensation जो है 11 A to GH or something like that. So all these components of remuneration now are excluded from the wage definition. See, what I'm going to tell you is, so far आपको, if you know the Supreme Court and certain High Court judgment, so the interpretations which were there, whatever you pay uniformly, universally, all these things were there. No, so this will undergo a change because of this definition. So now what the code is saying, whatever you pay at the inclusion part, that is wages, and whatever exclusion, they are not wages. But this definition has got certain difficulties because of one proviso. एक first proviso में लिखा है, see, this meaning is provided that for calculating the wages under this class. I will read it and then I will also try to explain about this. This is where the difficulty arises and there is a complexity arises. If payments made by the employer to the employee under subclass A to I exceeds one of or such other percent as may be notified by the central government of all the remuneration calculated under this class, the amount which exceeds such one of or the percent so notified shall be deemed as remuneration and shall be accordingly added in wages under this class. See, why this provision has brought, because आप जो employers होता है, now we keep low basic and wages to reduce our burden on PF and gratuity. So probably the law would have understood this, and that is why it wants to make certain portion of your wages for coverage of social security like provident fund and gratuity. So what is this provision is saying? Suppose जो आपका exclusion है A to I में जो है, उसका total amount 50% of all the remuneration के ऊपर हुआ, तो जो excess होता है 50% के ऊपर होता है, उसको आप wage inclusion part को add करने का है. So then by adding that, what happens, your included part or basic wages or whatever you call it as, that will get increased and provident fund and gratuity contribution will be more. So this is quite difficult to understand. हम एक example ले लेंगे. See, the example is, for example, आप पकड़ो आपका total remuneration. So suppose your entire CTC works out to rupees 10,000. आपका CTC जो लिखा होता है वो 10,000 है, and the amount in the first part is 4,000 rupees. So जो मैं बोला आपका inclusion part होता है basic DA and retaining allowance. वो retaining allowance is only applicable for seasonal establishment and agricultural based industries. So you don't need to worry more about retaining allowance, but you can say आपका जो basic and DA होता है वो 4,000 है, and the total of A to I works out to rupees 6,000. A to I is nothing but आपका exclusion बोला ना हम, वो 11 exclusions है ना. So that and all the amount is working out 6,000 rupees, and the one off of all the remuneration is 5,000. So total remuneration is 10,000. If you make it 50%, then that is 5,000, and therefore the A to I amounts exceed by rupees 1,000 rupees. वो exclusion amount जो है वो 6,000 rupees है, whereas one off है 5,000 rupees है. So exceed कितना हुआ? 1,000 हो गया. So now you have to add this 1,000 rupees to the wages in the inclusion part. So जो आपका कवरेज के लिए जो वेज होता है, then that becomes 5,000 because आपका inclusion part में 4,000 था. now 1,000 आप ऐड किया तो 5,000 हो जाता है. So आप परसेंटेज लिया तो your inclusion part हो जाता है 50% of the total remuneration. So the intention of the law is to at least make a provision for 50% of the wages to be covered for social security benefits like provident fund and gratuity. So that's why in my previous videos also I talked about it more about this, the complexity of it. But इसमें ये complexity है, वो wage definition में बोनस भी लिखा हुआ है, पीएफ भी लिखा हुआ है और ओवर टाइम अलाउंस भी लिखा हुआ है. So ये सब मिला के कितना होता है हमको मालूम होने का है. So once you arrive it, again you have to re-arrive it. So it is like a vicious cycle. So it is it's very difficult to explain also. वो एक cycle बन जाता है, then you don't come out of it. So इसके लिए थोड़ा ये उसमें मुश्किल है practical implementation के लिए. But what I am saying is, going ahead, this logic, the court may not agree with this logic, and they may either review this definition or there are chances that the courts may struck down also. But as far as now the code is provided and it is passed, so until there is any interpretations like this, so we are bound to practice it. And that is why at least our advice is keep as maximum as possible the included component of the wages, so that you don't come to clutches of compliance issues. So that is my advice for all of you. And this is not very important. And now there are some new definitions have been brought, including this aggregator, which are digital intermediary, and मैं आपको बताया career center, platform worker, gig worker. See, this platform work is nothing but people who use the internet platform and provide services and solve the problems. Gig workers are nothing but they are not regular workers like permanent employees and something like that. See, people who work on their own will, they are called as gig workers. So those are employees are also today. आपको पता है वो Zomato, Ola, Uber, all these have come. So these are all the people, they are unconventional, non-traditional employee mode. So that is why the code would like to cover all these employees also. I think I was reading the newspaper today. I think 25 crore of the population of India also as an unorganized sector, the code wants to cover it. So that is the today's news for you. Now let me briefly tell you what are the key changes. So Rishabh, I still have time, right?
Yes sir, no worry, you can carry on.
I still have time, right?
Yes, sure sir.
Okay, so मैं आपको की चेंजेस वो जो एम्प्लॉइज को बेनिफिट हो जाता है, so उसके बारे में थोड़ा मैं आपको बताऊंगा. पहले क्या आता है ना, मैं आई ऑलरेडी टोल्ड यू, ये कोड में जो है it wants to provide social security to all employees, whether in the organized or unorganized and or any other sector. So this is one of the good news for the employees. And जो already मैं बताया, nature of work or the employment type is not the criteria. Everybody उसकी इसका कोड में अंदर आ जाता है. So second reason है the wage के बारे में बताया. So the portion of your wage for the coverage of social security benefits, especially your basic and DA, for coverage of provident fund and gratuity, this will increase because मैं आपको बताया wage definition में जो proviso first proviso लेके आया है. So because of that reason आपका salary जो होता है for coverage of social security benefits, that portion ज्यादा हो सकता है. Now next benefit है, the scope for the coverage of ESI is extended to hazardous or life threatening occupation. Even उसका वो आपका industry hazardous or life threatening है, उसके अंदर even one employee is also there. So ESI provisions coverage लेके आया है. और आपका वो underutilized ESI hospital can also be made available to general public or other beneficiaries on payment of certain user charges. Suppose एक एरिया में एक ESI हॉस्पिटल है, उसका यूटिलाइज नहीं हो रहा है, So then the government can allow general public to also utilize that hospital for after paying certain user charges. So this is not a new provision. ESI Act में ये था. It was not implemented much wider. So now the government is serious about it, and probably it will also implement this provision. And moreover, the various benefits under ESI schemes can be extended to unorganized workers, gig workers, and platform workers and their families as well. So ये provision लेके आया है. So the ESI scheme also can be extended to all these kind of unorganized workers. And fixed term employees के बारे में मैं बताया. So this is an explicit provision. So उसको भी अभी gratuity और statutory benefits are applicable under the code. So this is also one of the good thing of the code. And the central, another point you have to remember, the central government has the power to order for payment of gratuity and happening of any other event which will get prescribed. So gratuity की क्या होता है? Suppose anybody dies, then for death there is no minimum qualification criteria is there, but for others he has to complete 5 years or more. But now there is a special provision where if there is any happening of any event, ये क्या है happening of any event, so that we don't know still. So this may get prescribed in the either in the rules or separately. So for example, any company gets closed after completing 2 years. So in that case, whether gratuity is to be paid or not is still no man's land. So probably the law is hinting that certain events हो जाता है, close हो जाता है, company close हो जाता है. So ऐसा situation में gratuity पे करने का है, नहीं पे करने का है. Now the central government बताएगा whether to pay or not. So that is why the law is hinting. Now the code covers all unorganized workers along with platform and gig workers जो मैं आपको बताया. So इसके लिए government is thinking is toll-free call centers or helpline facilitation centers. So they will bring all this thing to extend social security schemes. And उसका registration जो होता है वो unorganized sector employees का registration जो होता है, so they will make it electronic registration and self registration. So उसके अंदर ये जो गिग वर्कर से प्लेटफॉर्म वर्कर से ये सब उसको उसमें लेके आ सकता है. और ये जो गिग वर्कर्स और प्लेटफॉर्म वर्कर्स है, पॉसिबली ये प्रोविडेंट फंड स्कीम जैसा स्कीम है ना, so it is possibly that they also may get extended to these sectors. See, if you read the provisions of the code, then the government may mandate contribution of certain percentage of their turnover. Then based on that, they will extend the provident fund also to unorganized sector workers like gig workers and platform workers. So these are the provisions especially for unorganized workers have been brought. Now Aadhaar, this provision is also brought. So your Aadhaar will have more value and become important as this will become mandatory for all these schemes and benefits. So Aadhaar will become more and more important. So without Aadhaar, registration वगैरह और getting facilities will not get completed. So ऐसा लेके आया है. Changes which benefit employers. See, the first one is who is responsible for payment of social security contributions to contract employees like EPF, ESI, gratuity and maternity benefit. And this is also one of the much debated and complex topic, because जो आप each legislation पकड़ो उसमें definition पकड़ो then interpretation जाओ ये सब था. So now looks like there is certain clarity is brought because वो कॉन्ट्रैक्टर जो है उसको भी अभी एम्प्लॉयर जैसा इंक्लूड किया है. सो इसके लिए थोड़ा क्लैरिटी हम उसमें देख सकता है. तो ईएसआई में जो था और पीएफ में जो था, so first instance the principal employer is responsible, and if he is he is not able to pay or if he defaults, then the principal employer is responsible. ऐसा जो judicial interpretation था. और क्या था, if the contractor has any independent code numbers and ESIPF, then principal employer is not responsible. So considering the current jurisprudence, now because of the interpretation of the employer definition, so in my view the same interpretation will continue because the contractor is also an employer as per the code and is equally liable. And However, it is, employers have to be careful, because if you select some employees who have no ESA and PF code numbers, the liability can always be put on the principal employer, because the first instance principal employer definition is available and contractor is included as an employer. That is why you have to be very careful. You should not select anybody who does not have ESA and PF code numbers. And recently, if you see, there are certain cases, if you are supervising, if the contract employees are under your control, then the principal employer responsible. So therefore, these precautions you have to take care. And coming back to gratuity maternity benefit, see, current law bolta hai, for gratuity and bonus, the principal employer is not, responsible. So this situation will undergo a change, because if you look at the employee and the employer definition, these contract employees are also very much covered. So that is why this will undergo a change, and terms of contract are required to be very precise. If the principal employer wants to escape, so जो terms and condition होता है principal employer और contractor के बीच में, so वो थोड़ा ज़्यादा precise होना चाहिए, और it has to be, written down properly. So in that case only principal employer can escape. So even in the case of compensation also, the principal employer is, preliminary responsibility. However, uska, Employee Compensation Act or code may be provisions say, if there are proper conditions between the employer and the principal employer and contractor, then contractor can be made responsible. So even in case of maternity benefit, both contractor and principal employer can be held liable if the terms between the principal employer and contractor are not properly defined in the contract. So therefore, if you look at the definition of women in the Maternity Benefit Act as well as in the code, it includes whether employed directly or through any contractor. So therefore, if the terms and conditions are not very clear, जो principal employer और contractor के बीच में जो agreement होता है, if that is not clear, then the principal employer can always be held liable. So therefore, my advice is, so जो आपका वो contract होता है उसको जबरदस्त बनाने का है. So if that is very clear, then probably we have some answer on this, responsibility. So now coming back to fixed term employment is now as an explicit provision, as I said. So what I'm saying you is, this can definitely become a game changer in the Indian employment law, because if you look at so far what has happened is, this is always subject to certain restrictions, certain conditions, all those things were there. Now, because of the definitions in the IR code and also in the Social Security code, those restrictions I don't see. For example, जो था उसमें previously जो था, you cannot convert permanent jobs to fixed term, ऐसा कुछ conditions लिखा हुआ था. So अभी definition देखा तो वो such those conditions are not there. But however, I always have a doubt, whether this concept will get accepted by the courts or not. Luckily, if this concept and how the law wants to implement these provisions, if the courts accepts, then it is definitely a game changer in the Indian employments. So we will all have to wait whether in the same spirit it gets accepted or not. However, मैं बताया आपको, so employer is required to pay gratuity and other statutory benefits irrespective of whether he qualifies as per the statute or not. And now, previously, deposit of the amount due if the appeal is preferred by the employer against the orders of PF authorities. Suppose a PF inspector, makes a certain assessment, and suppose you want to appeal on that, so you are supposed to, maintain certain, pay certain deposit before going on appeal. So that deposit under section 7 was 75% of the amounts due. So code में क्या लेके आया है? इसमें you are only required to pay deposit 25% of the amount due. So this is one of the good provision for the employers. Now the code is not saying you deposit 75% to go for appeal. So it is saying only 25% you deposit and go for an appeal. Now next one is possibility to have common creche facility by pooling the resources in their area, or possibility to avail any creche facility set up by government or NGO or any other private body. So I'm not telling that ये नहीं था, ये था, वो explicit नहीं था. Suppose the government says in the, the code says, if you have 50 or more employees or any such other number, then the employer is required to provide, creche facility. So whether he has got a facility or not was the question. So now the code has got explicit provision that you can outsource also. You can pool your funds and make your own common crash facility also. So something like that, the provisions have come. And so somebody has asked me maintenance of documents. Now these documents, records, registers, all can be maintained by electronic mode. You don't need any additional permission or approval is required. So code mein ye provisions already leke aaya hai. So that is why you don't need any special approval to maintain in electronic mode. Now next one is जो ये हम inspection हो जाता है ना, so इसके बारे में थोड़ा radical changes आया है. See, now going ahead, web-based randomized selection of inspection and calling information electronically will be a reality. आपको पता है income tax में already faceless inspection आया है. So that is why now as per this provision, both governments are required to lay down inspection scheme to implement these provisions. So you may see this faceless inspection. You are not required. आपको जरूरत नहीं है पीएफ डिपार्टमेंट जाने का, एसआई डिपार्टमेंट जाने का, ये जरूरत नहीं है. सो इंस्पेक्टर वो जो है आपको ईमेल पे या सिस्टम में इंफॉर्मेशन पूछेगा. So you are required to provide that information via electronic mode, and then if it gets resolved, then it gets resolved. So that kind of provisions are coming. And also going ahead, what happens is there will not be any jurisdiction based inspectors nahi hoga. So on an automated system, the department will select who has to go for which company. ऐसा कुछ आ जाता है. So that is why there is no jurisdiction area based inspection scheme, or inspectors will not be there in the future. Now coming back to limitation for recovery of dues from employer. Suppose आप पकड़ो, inspector has assessed your dues for 10 years. So question is whether the inspector has an authority to assess the dues for 10 years, 15 years. ऐसा कुछ difficulties था. ESI में हमको provisions था, he cannot go back more than 5 years. Oh, those provisions were not there in PF. So अभी uniform limitation लेके आया है. The inspector or the authorities cannot go beyond 5 years to assess your dues and recover. So जैसा uniformity लेके आया है limitation पे. Now, suppose you have done a violation. Now, even if inspector want to prosecute, under the code he is required to give prior opportunity for you to set right the non-compliance. Suppose if you set right the non-compliance within specified time frame, then no prosecution will happen. So, however, employer will lose this opportunity if the similar nature of violation is repeated within a period of 3 years. And now employers can now compound the offences under the code also. See, a compound or composition जो होता है, suppose you did a violation, you pay certain amount fine, certain portion of the fine, and get escaped from the, or get relief from the violation. So these provisions were majorly known for criminal laws and other penalty laws. So now these provisions are also brought now under social security and labor laws. However, there are certain criteria which I'm not getting into details because of the time. It's already 6:13. And now social security schemes can now be formulated with the sources of CSR funds also. So suppose any scheme is rolled out where CSR fund is allowed as a source. Now the employer can utilize this opportunity and pay his social security earmarked amount, and also discharge his responsibility on CSR spending. So don't ask me that, sir, what I paid to PF contribution, what I paid to ESA contribution, will it be CSR amount, or will it discharge CSR responsibility? No, it is not like that. Other than this ESI, PF and regular schemes, any other social security schemes which allow CSR fund as a source, if you pay to that fund only, then you can discharge your responsibility, otherwise not. So that is the clarity which is there. Now very briefly, next Rishabh, I may take another 5-6 minutes. Is that okay?
Yeah, sure sir, no problem.
Okay. So let me give you very briefly what was existing law and certain other key changes. जो ये कंट्रोलिंग अथॉरिटी ग्रेजुएटी एक्ट में था, so now it is made it as a competent authority, and maximum cap on the medical bonus to 20,000 था अंडर मेटर्निटी बेनिफिट एक्ट में. सो अभी जो बताया है इट इज नो, वो ऐसा कैप नहीं है. सेंट्रल गवर्नमेंट प्रिस्क्राइब करेगा फ्रॉम टाइम टू टाइम कितना मेडिकल बोनस देने का है, सो वो प्रिस्क्राइब करेगा. और एम्प्लॉय कंपनसेशन एक्ट में इन केस ऑफ डेथ जो था कंपनसेशन 50% of wages multiplied by the relevant factor or 1.2 lakhs whichever is higher. So now कोड में क्या है, सेम क्राइटेरिया है, वो that 1.2 lakhs or not, that central government बताएगा, so big brother बताएगा. And permanent total disablement is also same, 60% of wages multiplied by the relevant factor or 1.4 lakhs. So now that 1.4 lakhs or not, वो सेंट्रल गवर्नमेंट और बिग ब्रदर बताएगा, वो नोटिफिकेशन इशू करेगा फ्रॉम टाइम टू टाइम, देन the employers are required to comply. And funeral expenses in case of death under employee compensation act जो था it was 5,000 rupees, and central government had the power to enhance. Now code में 15 के बताया गया है, or the now instead of central government, the state government also can enhance in under their jurisdiction. So that provision has been brought. And जो कॉम्पनसेशन कमिश्नर था अंडर एम्प्लॉइज कॉम्पनसेशन एक्ट 1923 में, उसको अभी रीनेम करके कॉम्पिटेंट अथॉरिटी बनाया गया है. एंड मैं लास्ट स्लाइड में थोड़ा वो ट्रांजिशन ऑफ शेड्यूल्स में बताऊंगा कि which schedule now is retained and which schedule is not retained. And schedule 1 which is there in the code on social security, which defines the application of chapters, now there is no corresponding schedule because ये new schedule है. वो जो एप्लीकेशन था नई लेजिस्लेशन में, वो सब मिला के शेड्यूल 1 में बताया है. दैट इज व्हाई यू डोंट फाइंड एनी करस्पॉन्डिंग शेड्यूल इन द एग्जिस्टिंग लेजिस्लेशन. वो शेड्यूल 2 is list of persons who are employees within the meaning of the third proviso to class 26 of section 2. so इसके लिए एक सेक्शन है, ये एम्प्लॉइज कंपनसेशन एक्ट में जो था शेड्यूल 2, the same is brought now as schedule 2 in the code on social security. And a schedule 3 a list of occupational diseases. So this is basically schedule 3 of the employees compensation act 1923, and ESI act may be a schedule 3 tha, so the same schedules have been brought. And schedule 4 a list of injuries deemed to result in disablement and percentage of loss of earning capacity. So now that was basically schedule 1 of the employees compensation act 1923, and similar schedule was also available, schedule 2 of the ESI act 1948. And a schedule 5a matters that may be provided in the schemes like PF, EPS, EDLI. So this is schedule 5. But if you look at provident fund and miscellaneous provisions act 1952 में 3 schedules था, 2, 3 और 4. so वो तीनों मिला के एक schedule 5 बनाया है. और schedule 6 जो होता है factors for working out lump sum equivalent of compensation amount in case of permanent disablement and death. This is basically talking about the multiplication factors. Now this schedule was this employees compensation act में जो schedule 4 था, same schedule is now coming as schedule 6. And schedule 7 जो है this classification of aggregators. So मैं आपको बताया this unorganized workers like gig workers, वो ये सब लेके आया है. These are basically people who are working for Ola, Uber, Zomato, all these kind of people. So the code was required to mention who are these aggregators. So these aggregators are classified under this schedule 7. So to look into existing law, there is no corresponding schedule because it is a new addition. And schedule मैं already आपको बताया schedule 1 of EPF and MP Act 1952 and schedule 1 and 2 of Unorganized Workers Social Security Act 2008 so have been dropped because they have no relevance. Now I've come to the end, so I will just summarize, then after that it will be open for question and answer. See, overall the code, it is a good consolidation of the provisions of all the 9 legislations, and the new provisions are brought along with structural changes as well. And some of the changes and new provisions are leading to few more complexity and confusion. So Rishabh Saab ne bataya, because of this cut, copy, paste, whatever is being done, and in between there are some new changes here and there have been brought. So these changes have also brought certain complexity and confusions also. So that is why it is required to look into very detailed, and also interpretation issues also will come. And see, going ahead, what I'm saying is the law is required to mature in the days ahead by judicial interpretation, and also appropriate amendments considering the requirements and change situations is required. See, the law is still not mature. So when we start the application and requirements of the society, and also the courts of India will look into these interpretation issues, then only the law will become mature. And we may see the power conflict between the states and central government, because of any code of LELO, you take any code, whether IR code or social security code or OHS code or wage code, उसमें central government का power ज़्यादा हो रहा है. So that is why if there is a same government is there in central as well as in the state, there may not be any conflict issues. But if there are different governments are going to come, this conflict between states and central government may happen. It is only my view. Other people may have different view, but this conflict may definitely happen. And expert will continue to have their jobs considering the new dynamics and issues in the law. Like Rishabh Saab and like me, the people like me and Rishabh Saab definitely will have jobs, because law is not very simple. मैं आपको बताया ना, जो provisions है, जो complexity है. So therefore, experts like us will continue to have their jobs. So that's it. Now I am closing it. Thank you very much. My coordinates are already provided. Any doubts, any clarifications, you are always welcome. So my email ID, everything is there. Now open to Rishabh Saab.
Thank you, sir. Thank you so much. First of all, that was one of the best presentation I've seen. Like literally, you have worked really, really hard. I guess you should have some water at least, because you are speaking continuously for last 1 hour. So
give me 1 minute. You'll be back. Meanwhile, you start speaking. I'll just get some water.
Yes, no problem. तो मैंने सारे क्वेश्चंस नोट डाउन कर लिए हैं, और तब तक मैं आपको 1 मिनट रुको. तो आज मेरे साथ भी हैं. आप में से कुछ लोग जानते होंगे, ही इज आल्सो लेबर लॉ कंसल्टेंट सिंस लास्ट मेनी इयर्स, आई गेस 30 इयर्स. तो आज मैं घर पे हूं, तो वी हैव लिबर्टी ऑफ so Mr. Raju, he is my father. He is a labor law consultant since 1990.
Namaskar, vanakkam.
Vanakkam.
Are you from Chennai, by the way?
But the Tamil I understand a little bit. Okay, so because of the proximity.
Where are you from?
I am basically from Karnataka, but ये Tamil और Telugu जो होता है, these are similar languages, so we easily pick it up.
My father knows Kannada also.
So I know Kannada also, because I completed my engineering from Bangalore, and then I have served in first service in Chennai. So I know both of. नमस्कार. सर मेरा क्वेश्चन है पेंशन को लेके कि इसमें पेंशन की जो लिमिट 15,000 अभी है, और 2014 में जो अमेंडमेंट किया उसके बाद में 15,000 से ज्यादा वाला जो भी ज्वाइन करता है उसको पेंशन नहीं मिलेगी. तो इस तरह का कोड में कोई प्रोविजन डाला है कि पेंशन का लिमिट को बढ़ाने का या कुछ करने का? वरना एक स्थिति ऐसी नए लोगों के लिए पेंशन होगी नहीं.
कोड में जो बताया है, these are abstract provisions. See, आपका एम्प्लॉइज पेंशन स्कीम सेपरेटली था, और EDLI स्कीम सेपरेटली था, एंड प्रोविडेंट फंड कॉन्ट्रीब्यूशंस में जो रेगुलेशन आना चाहिए वो कोड में नहीं है. वो सेपरेटली अभी उसको नोटिफाई करने का है. सो वो नोटिफाई करने के बाद हमको पता चलेगा वो वेदर दोस प्रोविजंस आर ब्रॉट और नॉट. सो अभी कोड में वो प्रोविजंस नहीं लेके आए हैं.
गॉट इट.
इसी के रिलेटेड एक और क्वेश्चन है, वो जो काफी सिमिलर है इसी के लिए, कि बहुत सारे हाई कोर्ट ने एक बार डिसीजन दे रखे थे कि आपको पीएफ एटलीस्ट अपनी उस स्टेट की मिनिमम वेज पे डिडक्ट करना पड़ेगा, एटलीस्ट उस मिनिमम वेज पे. तो अभी तो बहुत सारे स्टेट ऐसे हो जा रहे हैं जिनकी मिनिमम वेज 15,000 से ज्यादा हो गई है. सेंट्रल की मिनिमम वेज 15,000 से ज्यादा हो गई. तो आपके पास में क्या होगा, धीरे-धीरे पीएफ एग्जेम्प्टेड लोग ज्यादा हो जाएंगे कि पीएफ पे और पीएफ होंगे, पेंशन के तो कंपलसरी हो जाएंगे.
करेक्ट.
उस तरह कोई भी प्रोविजन नहीं है.
That is why what now the government is thinking, वो जो PF का 15,000 था, वो that one will become 25,000 now. So if you look at recent, let me have the water.
Sure. So there are a lot of news articles related to that PF will increase to 25,000.
Now that will become 25,000 because of the same reason.
Right. So now I'll take a couple of questions from audience. So first, it is related to fixed term employment. So you said that
Okay.
it is a game changer. Why it's a game changer for employer?
Why I will tell you is because if you look at the fixed term employment so far, how the law has been evolved, there are certain restrictions and clutches. You can't, run your industry only by fixed term employment. So you can't run it. Suppose you have a fixed term employee and you continue to renew him for 3 times, 4 times, 6 times, then the courts will say, why are you keeping him as fixed term? You make him permanent. But those restrictions in the IR code and the Social Security code are not there. If you look at Employment Standing Orders Act amendments recently, so there were actually provisions were written that those provisions are, you cannot convert permanent jobs to fixed term jobs. These restrictions were still available. Now if you look at IR code and Social Security code, the code is not talking about all these restrictions. So now is the question is for us is whether the courts of India will accept the plain definition. If the courts of India accept the plain definition, now the possibility will come, you can run your industry by employing fixed term all along.
No, so what's the harm? I mean, now fixed term employees are getting gratuity, bonus, all the benefits. Then why would employer would like to make more fixed term employees?
No, yeah, more. Why would employer make more permanent employees? See, then where is the question of if suppose the fixed term employment is going to be the law of the land, then where is the question of permanency and continuity and working for lifelong 58? Where is that question then? So these all will change over, no?
Right.
So now I will run my industry and I will go on employing for 2 years, 3 years, and if I want, I will renew it. If I don't want, I will close it off. And after that, what will you do?
Right. So
That is why I am saying this will be a game changer in Indian employment situation.
Right. So no, if I employ a fixed term employee, according to new code, I need to give him gratuity, PF, ESI, all the benefits he will get, except I guess notice pay, all the benefits he will get, right?
Yeah, even if the notice pay is not written down in the contract, because after expiry of the contract, if your fixed term contract says that no additional notice are required, then you don't need to give. So if you write that you have to give notice, you still have to give.
Got it, sir.
And that is if you want to dismiss anyone after 11 months, there is no problem. आप कभी भी उसको हटा सकते हो. Otherwise आज की तारीख में किसी को हटाना बहुत मुश्किल काम है.
That is why मैं बोला ना, fixed term employment, if the courts of India accept as a plain definition as in IR code and Social Security code, that can become a game changer for Indian employments and Indian employers. I can continue to run my industry on fixed term employment 2 years, 3 years, 4 years like that, and I will not have any labor issues. ऐसा कुछ हो सकता है, but we will have to wait and see.
Right, sir. Rahul is asking, will this, I guess the rules will notified in April, right? Around April, possibility.
Social Security code draft rules II, but it is not notified. It is only circulated in closed circle. But now what the government, what it is required to do is they have to officially notify it for objections. Now it is only IR code rules are notified for objections, draft rules, and other 2 codes are still required to notify. And once they notify, there is a time after objection period is over, then the final rules and the appointed date is required to be appointed.
Right. So whenever this date is appointed, will it be automatically applicable to all the state, Rahul is asking, or individual state will have power to either hold it or apply it, whatever they want?
Now, see, fixing appointed date is the prerogative of central government. The moment central government makes its rules and the appointed date is fixed, whether the state government has rules or not, it is automatically applicable. So if I know the internal news, now the central government ministry had a discussion with all the state government, labor department and ministers. They have told you don't wait for the central rules, you have your own rules, and we are sure that before April 1st we are going to announce it.
Okay. One question is related to wages, and even I have some confusion regarding the same. What my understanding was that the 50% is off basic. That means if a wage is 100, and then you can give like 66, 67% to basic, and the remaining 33, because which is 50% of basic, to allowances. But you said that it is 50% of overall wages. So what is?
No, law is ऋषभ साहब आप आप पढ़ा तो वो सेक्शन वेज का डेफिनेशन आप पढ़ा तो it's not telling you whether you make your 50% basic or 60% of basic. It's not telling you. What it is saying is you have the inclusion part basic DA. ठीक है? जो exclusions है. Now there are 11 exclusions are given. Suppose that exclusion is more than 50% of all the total remuneration. जो excess होता है.
That's the confusion. Like, is it 50% of all the remuneration or the wages only?
No, all the remuneration. आप पढ़िए. वो proviso पढ़िए. If you want, I can read it for you. Of all the remuneration.
I read it right. You say I guess that's correct.
Correct. So of all the remuneration, so that is why it is very clearly saying 50% of all the remuneration. See, I gave an example. 10,000 is your all the remuneration total CTC आप पकड़िए. आपका जो exclusion था 6,000 में दिखाया. So now 50% of 10,000 is 5,000. Now your exclusion is 6,000. So your excluded component is 1,000 rupees more than all remuneration. So now you take that and add it to that 4,000. Now it becomes 50-50.
Right.
So if you understand the intent of law, at least it wants to protect 50% of your total remuneration for social security benefits. So that is the understanding which I have. But if you have a different understanding, I would like to know also from you.
So my understanding is the 50% is of your basic allowances. So for example, your overall wages is 100, then you can give maximum according to, and this is the opinion of most of us in consultant fraternity, that if you have 100 rupees wages, then you can give 67 to basic plus DA or and retaining allowance, and 50% of that is 33. So that comes out to be upper limit is 67%. This must be given, and maximum 33 should be given towards all the 11 allowances which the code mentions.
Correct.
So this is understanding amongst all the consultant fraternity. Your opinion is the first which I got.
Okay. आप वो proviso पढ़ा तो see it is saying all remuneration. So now you tell me what is remuneration? Remuneration के बारे में definition नहीं है. Correct. No, it is remuneration is not only basic or DA.
Right.
आप पढ़ा तो आप I can also read it for you. Let me see.
No, okay.
नहीं आप वो proviso पढ़ा तो let me tell you also.
You can share अच्छा okay. If you want, I can share on the screen also.
आप वो proviso screen पे share कर दीजिए थोड़ा.
Just a minute. I need to download the PDF.
Govind sir, your camera's battery is dead. Can you please switch your camera to your webcam, please?
आ गया. चलो, got it. Sir, do you know the page number?
Sir, your voice is not audible. I think you are on mute. Can you please check, Govind?
Yeah, 1/2 or such percent. ठीक है. Voice is not audible, sir. He can probably hear. Oh, something is fishy. हाँ, ठीक है. So I guess sir is not able to hear, but एक बार अपन let's read this. So provided that the calculating the wages under this clause, if payment made by employer to employee under subclause A to exceed 1/2 or such other percent as may be notified by central government of all remuneration calculated under this clause. The amount which exceeds such 1/2 or the percent so notified shall be deemed as remuneration and shall be accordingly added in wages under this clause. तो अब my understanding is, देखिए यहाँ पे remuneration word 2 बार आया है, remuneration यहाँ पे आया है and यहाँ पे आया है, तो it says that this so notified shall be deemed as remuneration. Shall be deemed as remuneration मतलब बाकी को remuneration नहीं मान रहा है वो, और इसीलिए ये 6733 वाला मुझे लॉजिक लगता है. So I don't know, we are not able, probably your okay. Anirudh, can we try switching the mic from the settings? Can we select the laptop mic? Because right now I believe the mic is select. Sir, there will be a settings. There will be a settings below. Have you joined from the phone? Otherwise, best what you can do is you can join from the phone also. We have sent you the link on the phone. You can just click on that and you will join.
Rishabh sir, he's trying to connect again.
Okay. हाँ, सो ये वाला एक पॉइंट है डिस्कशन करने का. अभी मैं कुछ एक क्वेश्चंस हैं, अगर सर अभी जुड़ते हैं तो वी विल डिस्कस ऑन दैट आल्सो. 1 or 2 more questions are pending, I guess. बाकी we have anyways covered most of.
यहाँ पर वो देखो ना, इसमें जो एग्जाम एक्सक्लूडेड में क्या लिखा हुआ है, एक्सक्लूडेड में.
Can you hear me now?
Yes, sir. Yes, sir.
Okay.
Hear you.
So I was supposed.
My understanding is of all the remuneration calculated, and then there is written shall be deemed as remuneration. That seems that the other part is not a remuneration earlier. So they are considering remuneration.
Correct. My interpretation is of all remuneration calculated under this class. So under this class means this wage definition. So because of that reasoning, I have come to that conclusion. But since it is also foregoing, it is saying shall be deemed as remuneration. So your interpretation is, since the next part is saying shall be deemed as remuneration, so now you are saying you are taking the first part as remuneration.
Right.
So it needs a little bit clarity and also interpretation. So there are 2 ways of interpreting also.
But my gut feeling is, whenever there will be some authority having the discussion, they will always point out that नीचे तो ये लिखा है deemed as remuneration. So authority will not budge and they will always bend the rules in their favor.
100%. That is why Rishabh Saab में जो बताया ना. So this definition requires a legal interpretation and interpretation by any court of law. So as long as any court of law will not give the interpretation, whatever I and you say is only our views.
Right.
उसमें एक चीज मैं बोलना चाहता हूँ कि जनरली अथॉरिटी के साथ मैंने बहुत डील किया है. इस कोर्ट से पहले भी मोस्टली अगर आपका 50% अलाउंस होता है ना, तो दे आर कूल. इफ अलाउंस आर मोर देन 50 तो प्रॉब्लम रहता था. ये एक बात है. अच्छा, इसमें एक चीज और है, एक्सक्लूडेड के अंदर बोनस डाला है.
Correct.
Calculated bonus at the time of inspection or at the time, because bonus are always calculated at the end of the year. So ये बहुत अलग चीज हो गई है. बोनस को कभी वेज का पार्ट गिना ही नहीं गया था. यहाँ कहीं ना कहीं वेज और अलाउंस का पार्ट ले रहे, वो थोड़ा अजीब सा लगता है मेरे को.
But correct. See, if you also see my talk during talking about it, so it becomes a vicious cycle, because bonus is now an excluded component. So how will you arrive at the total excess part? So once you arrive at the excess part, then that you add back to the inclusion part. So on that again you have to calculate bonus. So how long you will go and do it, right?
And the percentage of bonus you cannot decide till the balance sheet is not finalized.
Correct. It is paid after the finalization of the accounting year. Absolutely.
राजू साहब, ये तो बहुत अजीब चीज इसमें डाली गई है. ये मैंने भी पहले पढ़ा था. मैंने कहा बोनस इसमें डालना, अगर इसको किसी तरह से करेक्शन का लेटर या कुछ अपना सजेशन भेज सकते हैं तो ये जरूर भेजना चाहिए. ये तो हटाना चाहिए मेरे हिसाब से.
नहीं, मैं भेजा था.
अच्छा भेजा था आपने, ओके।
हाँ मैं भेजा था।
The last question.
Yes, sir.
What is compounding? Compounding of penalty. What is compounding?
See, compounding or composition are synonyms. Both are used as same. See, compounding is nothing but suppose any violation is is against you. Then, if it is proved against you in the court of law, then a punishment will happen. Maybe it is an imprisonment or a penalty of 1 lakh rupees or 2 lakh. The compounding is I will not go to jail, but I am ready to pay certain amount for that as a penalty or compensation, like that. So now I pay that money to whoever is notified authority. Now I go away from that prosecution.
Got it. Got it. Okay, sir. That concludes all. I guess I've taken all the questions from audience also, and our questions as well. Thank you so much. It's a pleasure. One of the best webinar I've taken and I've attended. Wonderful having you on LLA, and I have subscribed to your channel and regularly watch your channel and will continue to do so. That's a wonderful initiative you are doing.
Thank you. Thank you. It is all.
बहुत मेहनत किया। जिस तरह की स्क्रीन वगैरह आपने प्रेजेंट की, जिस तरह से आपने स्लाइड्स बनाई है, मैं जानता हूँ ये आसान नहीं होता है बनाने और करना, बहुत मुश्किल टाइम लगता है, लिखना पड़ता है। अपन वैसे कट पेस्ट नहीं करते जैसे किसी ने कट पेस्ट कर दिया है।
नहीं and moreover पढ़ना पड़ता है ना,
पढ़ना पड़ता है।
And he's a full-time HR GM. He has written a couple of books, and along with that, running a YouTube channel, and along with that, helping us with this webinar.
Oh, good. You are from which city? You are from Bangalore or where? Which city?
No. I am from Bangalore.
Oh, I passed BE from Bangalore. I was there in Bangalore.
In 84, which college?
BIT.
Very good.
I spent a really nice time in Bangalore.
Very good.
It was 79 to 84. 79 to 84.
Oh,
so
very
after
good.
Year, I become a labor law consultant.
Oh, very good. आप Bangalore आया तो मेरे को, yeah, if you come to Bangalore मेरे को call कीजिए.
बिल्कुल. You are from which place in Bangalore?
This is north part of it, this Pinya Dasaralli, you may be aware.
I may not be knowing, but okay, I can call you. I can call you.
Yeah. So nice. जयपुर आए तो मैं आपको फोन करता हूँ.
बिल्कुल.
And any suggestion for our HR fraternity, because you have spent 20 years in this field? There are a lot of fresher HRs in this group. So any suggestion how they should go about their career? Last point.
Yeah. See, what I see in today's generation is they want to make fast bucks, so which nahi chalega. So in my view, the hard work is missing. So they want to earn something and enjoy. See, if this trend continues, they will not become a serious professionals. So only thing is you have to work hard, and you have to learn the game. See, for example, people used to say me, because with last 20 years I have seen the life. People used to say me, no, I am stuck. I am not able to get power. So all these things were there. But somehow I did not feel that I have no power. Wherever I have gone, I have taken the power. And luckily, it worked for me, and people also have understood my dynamics. See, if you are a risk taker and challenge taker, then only you can survive in the industry. So if you don't take risk and if you don't challenge yourself, then definitely this is not the field for HR people. And I always say to my HR fraternity is that the toughest job you handle is the human resource. One example I will give you, because when you handle a machine, you handle only one machine. But when you are in HR, so if you have 500 people, you handle 500 brains. So
right.
one brain is equal to millions of thoughts. So imagine what tough job you are handling. So that is the challenge which you should be ready to face, and it is one of the toughest job, and of course very challenging. So you should be highly challenged yourself, and you should also take risk to come up in the life.
That's a wonderful thought, sir. So let's conclude on that thought. And thank you so much for joining today. It's a pleasure having you, and hopefully we will have you soon back on some other webinar as well.
Sure. Thank you, Rishabh Saab. Thank you for the opportunity, and also Labor Law Advisor.
and I told I also got little bit inspired and motivated from your channel, because I thought, okay, let me also do my bit to the society. And thank you very much for giving me an opportunity today.
Thank you, sir. Thank you. I'll share the recording with you soon.
Yeah. So, and also share the feedback if any.
Yes, sir. So already feedbacks are coming. Excellent webinar, marvelous webinar, full of information. Thank you for such a gift. Lot of comments are coming.
Okay.
Thank you,
Thank
sir.
you.
Thank you.
दिवाली गिफ्ट।
सो उम्मीद करता हूँ जो भी लास्ट तक रुके हैं आपको ये वेबिनार पसंद आया होगा, और इसी तरह से और एक्सक्लूसिव वेबिनार्स अपन करते रहेंगे। आप सभी को हमारी तरफ से हैप्पी दिवाली। मम्मी आप भी आ जाओ। तो सभी को हैप्पी दिवाली। दिवाली से पहले तो प्रॉब्लली लास्ट वेबिनार है। ये हमारी फैमिली है छोटी सी, मम्मी पापा मेरे। तो आप सभी को वेबिनार और सभी को दिवाली की बहुत बहुत शुभकामनाएं। बाय बाय।
बाय।